Donald Trump's defense drops a bombshell right into Judge Chutkan and Jack Smith's lap, saying that, hey, when this case goes to trial on March 3rd, conveniently right before Super Tuesday, right in the middle of an election season, Trump says, we'll be ready to go, and we're coming in hot. We're coming in with classified evidence. And this evidence is going to show that Trump was totally and justified to do what he did, which was to investigate a rigged election. And so we're going to go through that motion in detail. It's not long because it's classified. There's a lot of classified materials in there that Trump's defense can't really talk about. So we'll take a look at what they submitted and why the FBI and probably the CIA are all quaking in their boots over there. Oh, great. What's he going to talk about? And so we're going to go through that. Then we'll clear up this Mark Meadows story because Mark Meadows' lawyer had a response. There was a rumor going around that he was wearing a wire in the Oval Office. And that's, of course, not true, as we're finding out at this point. And we've also got some interesting filings from the media. They want access to all of this, right? So when Chutkan and Jack Smith bring in their trial and when Trump uses this classified material stuff to talk about what's happening, the media wants to be able to broadcast that. And boy, oh boy, wouldn't that be nice to have America be able to see it and be able to review what Trump presents? So we'll take a look at what the media says about it. We'll also see what Trump says, whether he responds to this, whether he agrees to cameras or not is to be seen. And then we'll listen to what Weissmann said, because he's articulately saying the same thing we've been saying here, that Trump is doing the free speech dance, right? He's really exercising this almost to goad the DOJ. And so let's start off with the motion. It is not long, but this one is packing a punch. That's why we want to see it, because here it comes. Pretty simple. And sometimes simplicity is what you need. It's a 3-pager. And what is this blue pen? Let's bring out the red and let's girth the pen up a bit. Perfect. So here, filed in the District of Columbia, United States of America versus Donald Trump. Pretty simple filing, only 3 pages. The clerk's like, oh, this shouldn't be a big deal. Well, guess what? This is President Trump's SIPA notice and objection to unauthorized deletions of classified information. So boom, notice, right? We're notifying you, everybody, this is our plan and this is the route we're going. So get ready, buckle up. They say, Judge and Jack Smith, on October 26, 2023, President Trump's counsel, his lawyers, provided to the classified information security officer. And remember, we're in the District of Columbia right now, but there are classified documents in this case. I know there is a separate Florida case that also is based about classified documents and classified materials, but that is not the case we're talking about, just to completely distinguish the two of them. We're in DC. This is the January 6th case, not about the Mar-a-Lago boxes at all. But in the DC case, there is also classified documents. Okay, they said that as part of discovery, Trump's team and his lawyers also have to go through the SIPA proceedings and the procedures to get cleared and everything. It should be quick because they're getting cleared in Florida and so on. So we're also having some complexities with classified documents and materials here, but Trump's people are saying this is in addition to that. They say here, we've provided to the security officer and for submission to the court and service on counsel a notice pursuant to the SIPA rules and an objection to certain redactions in certain of the classified discovery produced by special counsel's office. So 2 things happening here. 1, notification. Okay, the rules say that we've got to notify you if we do something like this. And 2, Jack Smith, the special counsel, they gave us a bunch of this classified discovery, okay? And they redacted all the stuff that we need, all right? We got these big tranches of documents and it's just all, blacked out. They're ridiculous. So we object to these redactions. And we're also giving you notice about our intention. So Trump's defense says, Chutkan, at the beginning of this month, Jack Smith's office, they came into this courtroom and they argued, they said the classified discovery issues in this case are, quote, limited and tangential and narrow and, quote, incidental because the charges do not rely on classified materials. Again, we're in DC, we're not in Florida. So they're saying Trump's so-called insurrection, the charges they're actually charging him with are not that. But they say that those are not based on classified materials, and so we're not too concerned about SIPA and those things. But Trump says, no, sorry. They say through the SIPA notice, President Trump demonstrates that the government appears to have looked with tunnel vision at limited issues it believed were relevant. They had that opinion. They came to their conclusion. They said, well, we think that, Jack Smith's looking at all the materials. He's looking at all the charges. And he says, Trump only needs this subset of classified materials because this is how we're structuring our case. And we think this is what he needs. But Trump's defense says, sorry, your little theory that means that you believe that classified materials are limited is wrong. Sorry, classified issues are not limited. They're not tangential. They're not narrow. Their office was wrong, they said. It's not much longer to go. This is Todd Blanche writing, saying, the indictment from Jack Smith in this case, deranged thug prosecutors, adopts classified assessments by the intelligence community and others that minimized and at times ignored efforts by foreign actors to influence and interfere with the 2020 election. And so President Trump will offer classified information at trial relating to foreign influence activities that impacted the 2016 and 2020 elections, as well as efforts by his administration to combat those very activities. President Trump will also present classified information relating to the biased and politicized nature of the intelligence assessments that he and others rejected during the course of the events in question, saying collectively, this evidence will undercut central theories of the prosecution, Jack Smith's entire case, and establish that President Trump acted at all times in good faith and on the belief that he was doing what he had been elected to do. Sincerely, your friend Todd Blanche and John Laura. So good stuff. Now, very short, but very powerful here. Okay, they're saying that Jack Smith believed that they had everything they need in this case without talking about classified materials. And Trump is saying, well, if you're going to go into my state of mind and you're going to try to tell me as the president that I was acting knowingly, fraudulently, right? That I knew that I had lost the election. I believe that and I knew it, but I was trying to steal the election anyways. Trump is saying, no, not at all. Okay, that's not the truth at all. In fact, Jack Smith adopts assessments that minimized and ignored foreign actor assessments. Okay, they're reading things in a way that serves them. But Trump knows the truth. Trump has classified information from his perspective that he also got that said, sorry, these elections were rigged and there were efforts. And so he's going to present his side of the story as well. And once you see that side of the story, you're going to recognize that Trump was obviously justified in his belief that this was rigged. And we know it was now because of what the 51 so-called intelligence experts did when they colluded literally with Secretary of State Anthony Blinken, who was working for the Bidens at the time. What they did on X, what they did with social media, censoring people, they have gone out of their way to move past that. But we can all see it now, as clear as day. Not to mention all the COVID rule changes and the constitutional violations that happened when the executives, like the secretaries of state, usurped the legislatures and took away the constitutional power from them by recreating the election rules in the pretext of COVID pandemonium. So this is the motion, very simple. And this is going to be very curious how this goes because Trump has, in my opinion, an absolute right to present this evidence. And the jury, they're all going to be a jury of his peers, so they're going to be listening to this evidence. And the media, they want to be broadcasting this evidence. And so how are they going to finagle all of this? Well, as we can see, we're going to continue to cover it. Now, we're going to go to the media and their desire for access. But before we get there, let's clear up this Mark Meadows story because this is also an interesting subtext of a lot of this, right? Classified materials, are there moles? What else is coming out? Are people flipping? What is this case going to look like? Well, there was a rumor out there that Mark Meadows was wearing a wire, right? That he was being colluded with the FBI to go and tap the Oval Office and so on. Well, it turns out that story has been denied by Mark Meadows and his defense team, and it didn't have the right feel to it when we first listened to it yesterday. But Catherine Herridge also came out and said the following, said, here's the statement from Mark Meadows, the chief of staff, the lawyer for him. His name is George Terwilliger. He says, when the government identified Mark as a prospective witness, Mark Meadows committed to telling the truth and only the truth. Time and time again, he sought to protect presidential privilege and testified when the law required him to do so. Stories claiming to have knowledge of a deal or that he has some form of animus towards President Trump have zero idea what they're talking about, and he will not be intimidated by anyone. All right, that's from George Terwilliger, Meadows' lawyer. And, we were cautious with this story when it originally broke because it didn't feel right because Mark Meadows, as we've seen here, has been fighting pretty hard, actually. I mean, he fought very aggressively when he was trying to get his case in the RICO case with Big Fanny removed up into the federal court system. And we've seen even Trump come out and kind of stand behind Mark Meadows. I think some of these rumors are off. And so I don't know exactly how this story got percolated. I do know that originated largely from this guy yesterday. He got his tweet or his breaking of the story was really what caught a lot of attention. He has since deleted that tweet and he has now published this. He says, yesterday, I put up a tweet alleging that Mark Meadows wore a wire in the White House during the last stretch. I've spoke with my sources again. Now it seems the information was wrong and incorrect. In fact, two of them retracted their statements on the matter entirely. Now I apologize for putting something out without it not being 100% accurate. That's on me. I'll do better next time. I also apologize to Congressman Meadows and his staff for having to field questions on the issue. There seem to be some dark forces behind the scenes trying to get Meadows, and to me, that's very problematic, especially when it seems like it's been sent through the grapevines by some of our own. And you can see this has gotten a lot of play, right? 1.7 million views here is a lot. And this is the apology. This is the retraction. The other tweet got a lot. So we were asking about the sources, right? Who is promoting this stuff and who's trying to cause some of this division, because I have some concerns about this, my friends. I think that it is not a good tactic to try to drive these potential witnesses out of the Trump camp, however you want to define that. You know, whether it's Sidney Powell, Kenneth Chesebro, Jenna Ellis, Mark Meadows, Rudy, anybody. The idea is we're all friends, okay, until they give you a hard reason not to trust them or something. You know, it's better to keep them close as much as we can. And so I want to be cognizant that, you know, anytime something like this happens, my original instinct, my initial instinct is going to be, okay, maybe they're, you know, how can we salvage this? Because what we absolutely do not want to happen with Meadows or any of these people is basically what happened with Cassidy Hutchinson. And Cassidy Hutchinson turned into a big problem because we saw some text messages that we covered here. Sounded like she was reaching out looking for help from the right side, and she couldn't find it. And so where did she end up? Running right into the bosom of Benny Thompson and Liz Cheney and Kinzinger, his giant bosoms. So she was there, right? And she was up there, clavicle attack, because she was captured by the other side. So I want to be very careful about this. And I know a lot of people are upset about the plea deals being taken and all this stuff, but until we see something concrete, I think the smarter play is to keep potential witnesses, adverse witnesses, in the fold. But he says this, right? And so my point is, who is the person who is spreading these claims? He says, I'd also say this. Now, I have no clue if the original source in terms of the knowledge, if he's the original source. Walker's a good man, don't get me wrong. I think a lot of people got lied to. Again, I'm sorry. All right. So he apologized. We don't need to belabor that anymore. But the question was, who was promoting that? And are those same forces promoting other fractures within this journey that these cases are on? So that was the clarification on that. So, you know, if we see stuff like that pop up, we're just going to keep our eyes on it and be ultra skeptical on it until we see some filings. That's generally why we like to wait for filings and for some court activity, because otherwise it's just kind of rumor and speculation. But when this was breaking, they were asking Jim Jordan about it. And so even Jim Jordan's like, I don't think this has any legs to it.
There's been reports. There's been a lot of scuttlebutt that Mark Meadows, former chief of staff to Trump, at one point I read may have worn a wire while he was chief of staff. I know Mark very well. You know Mark, you're good friends. I just don't believe any of this. Do you know anything about this? Has he turned on Trump? Can you tell us what you know?
I don't, but I don't believe anything that gets written about you know, from so many people in the mainstream press. I don't believe Mark would do that. Mark's a good friend, but I don't know. But I trust that Mark thinks the world of President Trump, as do I, and I know you do as well, Eric. I want him to be our next president. I think Mark's the same place, and Mark is a good man, so I don't believe what the press writes about him.
I will.
All right, so I think I agree with that. And that's kind of been my take with a lot of these people, is that maybe they're no longer, you know, ultra MAGA, as to use a Biden term or something like that. But, you know, they still are on, you know, they believed what they were doing. You know, I don't think that Sidney Powell or Jenna Ellis or Kenneth Chesebro or Mark Meadows or anybody thought that they were criminals, that they were going out there to insurrect America and to do this racketeering scheme to go and take over the country. Like, that was never anybody's intention. That's all a fiction from the left that they've got created to give themselves nightmares every night, you know? So the reality is, you know, Mark Meadows, what's he going to say? Yeah, we thought the election was rigged. I had some disagreements with Trump, but it didn't feel right. So we just want to keep an eye on that and make sure that that's clear. And I think the better strategy, until we have concrete evidence that something is really awry, keep people in the fold. And then if they turn, then you can cross-examine, obliterate them and say, well, didn't you say this in your book? Weren't you tweeting this like 3 months ago? Didn't you say this on CNN too about how you thought it was rigged? Right? All of these people are subject to cross-examination, and they can live with their own records, which have all been supportive of Trump for a very long time. So, all right, enough out of me on that one. Now, the media certainly wants to hear about this, and so do we, and I'm very excited about this. You know, they said that we were going to get a lot of camera activity. We've gotten some camera activity out of Big Fanny's case in Georgia, the RICO case. Trump, of course, is not scheduled for trial on that one until who knows when. But then we've got 2 federal cases where we are not allowed traditionally to have any media access in federal court. The media wants access to it. Of course, so do we. And so let's see what they filed when they were demanding access. This is the coalition, the media coalition. Okay, they want access. They want to see all of this stuff. And I would like to see it too. I think that it should be public because this is one of the most important issues in the political cycle, arguably American history, because it dictates the future of really the justice system and whether politics can be subject to criminal prosecution on the whims of a special counsel or a Fanny. So here is what the latest looks like. Now, this was filed some time ago, but Trump has just been ordered to issue a a response if he wants to. And so the judge is now taking this under consideration as of now. They say, look, all these people, all the media, I'm with them. Let's see it. They say here, ABC, AP, Bloomberg, Wall Street, CNN, National Photographers, Politico, okay, everybody, Washington, blah, blah, blah. They say here, we respectfully submit application to record and to telecast the March 2024 trial of Trump. Alternatively, the Media Coalition respectfully requests that the court publish on YouTube its internally administered audio-visual live stream and recordings of the proceedings. Yeah, just put it on the YouTubes and we'll stream it here. As a final alternative, so let us get in there with cameras and broadcast, or take your current feed and put it up, or release the video recordings after each day when the case is done. Now, as the U.S. Supreme Court observed over 4 decades ago, First Amendment right for public to attend criminal trials. Say it's important that we can see what's going on here. The prosecution of Trump, now a presidential contender, on charges of subverting the electoral process, whatever that means, presents the strongest possible circumstances for the continuous public oversight of the system. Now, that oversight rooted in decades of First Amendment protection, and through counsel, through lawyers, Trump has repeatedly spoken out about the importance of cameras in the courtroom for his benefit. Trump wants them, and that of the court. They say real-time video coverage will be critical in stemming false conspiracy theories across the entire spectrum of public opinion, regardless of the trial's outcome. Which I agree with. Yeah, let's see it. Because I think Trump's defense is much stronger than their case. I think we're going to see a recreation of the January 6th committee hearings, except this time we're going to have some cross-examination and some opposing witnesses and some alternative theories. So if you thought the January 6th hearings were a joke, well, they're going to be made to look like a big joke when there's actual process there. Because that was basically the research project from Liz Cheney. She put together a book report and gave it over to Jack. So they say, now, Your Honor, listen, we know there's Rule 53, okay? And the federal rules of criminal procedure, and there's a local rule. Now, I'm going to ask you guys what you think about this. Do you think that Trump is going to respond yes or no? He doesn't have to respond, as we'll see. Is he going to say, I agree, cameras in the courtroom? Respond, I don't agree. And then what is Chutkan going to do? Is she going to grant them or not grant them? And if she does not grant them, what is the justification going to be? So be thinking about that when we get there. So the rules on their face create a per se prohibition. Okay, it's blanket. I've read it. Prohibition on the broadcast of criminal proceedings to those unable to attend in person. Now, even though those rules exist, the First Amendment, they say, is stronger. And to be meaningful in the unique circumstances of this case, which is incredible, right? Even the media acknowledges, like, this is historic, this is novel, this is incredible, never before in the history of this country ever seen anything like it. And then Judge Chutkan's like, well, it's just a regular case. We'll see you in court. You're just like any other regular defendant. And you're gagged, too. Shut up. Wild. So they say that right must include a right of first-hand observation. Now, while other federal courts have not yet recognized the First Amendment right to telecast criminal trials, the Supreme Court has not squarely addressed this issue for some time, and the D.C. Circuit has not either. And because your rules and your per se bans are outdated and their long disproven views, you say those are unpersuasive here. This is historic and unprecedented. I'm really glad the media agrees with Trump's defense on this, by the way. Trump has said the same thing. And Jack Smith's just like, no, he's just like a regular criminal, just treat him like whatever. Those rules simply cannot justify restricting the public's right to view. A per se ban is unconstitutional here. And so the Media Coalition respectfully asks that Americans can see and hear the trial and other proceedings in real time, as is their right. Now, here's a quick background. They say, following the election, Joe Biden was elected. And then President Trump refused to concede, said the election was rigged, and said there was tremendous voter fraud and irregularities. All true. On January, hours before the joint session, Trump took to the stage, some armed with weapons and wearing full tactical gear, like water bottles, marched to the Capitol along with Ray Epps and violently broke into the building with at least 50 CHSs that we know that the FBI or Homeland Security had there. Now, Trump was impeached and acquitted for incitement of insurrection the following week. 5-day trial. Trump, of course, was acquitted. Proceedings were televised, and that basically invalidates this entire criminal prosecution because he was not actually convicted in the Senate. So all of this is illegitimate. We'll see if the Supreme Court agrees, but that's my opinion. So the proceedings were televised. 11 million viewers watched it. House of Representatives initiated its own investigation. That's Liz Cheney's hearing. 20 million people watched it the first day, and then it dropped off because it was very boring. So they say the indictment came out, and it had a bunch of things saying Trump knowingly made false claims about fraud, right? Knowingly made false false claims, which he's going to say, no, there's classified documents. I'm going to show you that I had a good basis to believe it. That's why I believed it. So the indictment asserts 4 felony counts: conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an official proceeding, and conspiracy against rights, 18 U.S. Code 241. They say trial in this case is scheduled to begin on March 4th, the day before Super Tuesday, when everybody's going to go vote in the primaries. Incredible, isn't it? They say it's unclear at this point how many members of the press and the public will be permitted to appear in trial. The media says, recognizing there's limited physical access to this thing, Trump's lawyer has publicly called for televised proceedings, noting that the public should be able to weigh the evidence against itself. I agree. Says, if I appear in court, I'm going to be representing not only the president, but the sovereign citizens of this country who deserve to hear the truth. The first thing we would ask for is let's have cameras in the courtroom so that all Americans can see what's happening in our criminal justice system. And I would hope that the DOJ would join in on that effort and that we can take that curtain away and let all Americans get to see what's happening. And if they don't, then, obviously we're going to be going through the trial transcripts here to make sure this is etched in the digital space as best as we can. But that's absolutely right. Now, this leads me to believe that this will not obviously be granted, because if Trump wants you to see what is happening, you can infer that the government is not. And so you can come to your own conclusions about why that might be, but let's save that for a bit. Now, in contrast to federal courts, Georgia State Court has announced that they will be televised. And of course, we've been following all of those here. So they give us their argument. They say what happens in the courtroom is public property. Involving other cases, we found that the press and the public have a constitutional right to access the trials. Meaningful access. They're going to make their case here. They're probably going to be stretching. Meaningful access is the right. And so the rationales for criminal proceedings have particular resonance in this case, because a polarized electorate includes tens of millions of people who, according to opinion polls, still believe that 2020 was decided by fraud. This is a June 2020 poll. Here's what the numbers say. 3 in 10 Americans, 30% of us, including 2/3 of Republicans, believe that Joe Biden only won the presidency because of fraud. The rationale for this is that more people who voted for Trump believe this. They say a lack of openness can lead to distrust of the judicial system. Absolutely. Doing all of this under the dark of night, particularly if the outcome is unexpected. Now, openness enhances the basic fairness, and there can be no dispute that the public, we the people, have a constitutional right to access these proceedings. And I completely agree with the media here. It should be meaningful access, okay? Not Judge Chutkan coming out and saying, well, somebody can go sit in the media room if they want to. Well, all of us, all 81 million Americans can go sit and watch it? No. So they say, here, Your Honor, the right of access is grounded in the First Amendment, and it's more than theoretical. In a case like this, as a practical matter, it's going to affect literally hundreds of millions of people, and the right must mean more than limiting access to fit a few into a small courtrooms. Historical tradition of meaningful access means it's got to be meaningful. Here's a historical thing. They say it is telling that after former Vice President Aaron Burr was arrested for treason in 1807 at the order of Thomas Jefferson, the president, Chief Justice John Marshall decided to move the trial to a much larger hall in the Virginia House of Delegates in Richmond to accommodate the high turnout, allowing those of the public who wanted to attend the opportunity to do so. Okay, so they moved a whole trial into a bigger location to accommodate the public. As a result, thousands of people thronged into the courthouse to see and hear the proceedings. More than 2 centuries later, no legislative hall is capable of taking in all of the Trumpers who want to see it, and everybody else, all the lefties who are salivating over it. So they say remote and virtual attendance is consistent with our tradition. We saw the George Floyd case was televised. The state court for Derek Chauvin was televised, and they came up with a conclusion, and so you should do the same thing here. They say now live streaming and TV are everywhere. Technology has evolved that the presence of a camera in a courtroom is totally unobtrusive. It's not going to bother anybody. Just let us set up a camera right around the corner in the back there. They say many Americans now expect to see the recordings and recognize that we should. So it's not going to be unobtrusive. The simple presence of an unobtrusive thing is not going to be a problem. The means exist today to make this happen. Now, 17 years ago, there were some other rulings, but a lot has changed since that time. And so this trial should be televised. Now, if you're not going to allow us to televise it, then you should allow us to publish the live streams on YouTube right here. During the COVID emergency, we know that your court utilized equipment to publish stuff on hearings, to publish stuff on live streams. So posting these on YouTube so that we can live stream it here, said it would profoundly increase the number of members who could watch the stream. streams. Alternatively, the court records audio and video transcripts, and so you should just publish those. They say, Chutkan, we have never, in the history of our nation, had a federal criminal trial that warrants audio-visual access more than the federal prosecution of President Trump. Agreed? The central purpose of the constitutional right of access that here governs is to ensure fair trials and to promote confidence in the justice system. But they know if they show us what happens in there, we will have less, not more. Broadcasting the trial in this case will clearly advance that interest. And so for the reasons set forth, the media, all of us, request that you enter an order, Judge Chutkan, permitting the live broadcast of this courtroom. Alternatively, broadcast it on YouTube or give us the hard files at the end of the day. We ask that you do this, signed your friend Chad Bowman on behalf of all of the people in the media. Now, we just got an order from the judge. She says, all right, Trump, if you have a position on this, let us know. Said here that all the defendant combined response says if the media coalition's application, if any, okay, so Trump doesn't have to respond, but the combined response, if any, to their motion shall be due. It's due by November 10th. Let us know. And so the question to you is, one, is Trump going to respond? And two, if he does, what is his position going to be? And is his position going to be cameras in the courtroom? Which I think he will. That would be my take. I think he'll respond and he'll say cameras in the courtroom. We'll see. Next question for prediction time. Judge Chutkan, what is she going to do? Is she going to grant it? Grant cameras in the courtroom? And if not, why not? And I say the answer is no. She's going to say historical tradition. She's going to say it involves classified documents. She's going to say it's necessary for safety and security and to protect everybody. And she's going to say that it's done to protect the integrity of the proceedings. That's what it's going to be for. Predictions. We'll see. Drop yours in the predictions and we'll see what she does. Now, here is a clip from Weissmann. Now, what he's saying here is mirroring a lot of what we've been talking about, that Donald Trump is goading, okay? He's exercising maximum wingspan of his free speech rights to really, maybe try to goad the other side into doing something. And this was a wild exchange. Listen to these people on MSNBC. We'll see how much we can get through here.
Andrew Weissmann, deal with this specter of prison time with you. I mean, this case doesn't represent the threat of incarceration for Donald Trump.
They're talking about New York. She's upset that he's not going to prison for this.
The Mar-a-Lago documents case, yes. Georgia, RICO, yes. Jack Smith's election interference case before Judge Tanya Chutkan, yes. But this one, and as everyone has said, he's already been found guilty of fraud. This is about assessing the punishment, the damages for that conclusion, but it doesn't hold any risk of jail time unless, in the words of Judge Engoron, Trump continues to defy this very narrow gag order to not threaten, malign, intimidate, and endanger the safety of his clerks. What is wrong with someone who is basically running through the red flag, I guess, being waved in front of him?
He's exercising his free speech against a political partisan prosecution. That's all you can do. That's why we have the First Amendment. But these people don't understand the Constitution at all.
I think I'm going to channel Neil Kochel here because I think this is what's going on. You have a day that, as Lisa said, should have been simply about civil liability, where Michael Cohen on the stand made admissions that are very damaging to his credibility.
Yeah,
obviously,
he said,
the judge is the ultimate decider what to believe, any or all or none of what he said. But he made very serious admissions about his having lied in the Senate interviews and in federal court, not once, but twice, to Judge Pauley when he pled guilty. So this could have been a day where there were just legitimate references to undermine his credibility, and in very, very serious ways that you could have taken that route.
Now,
instead, this is, I think, a very deliberate strategy. And as the judge found, it was palpable that this was a reference to the law clerk, not to Michael Cohen, where Trump is, I think, deliberately playing to his base and goading the judicial system as part of a strategy in terms of his base, in terms of his political campaign, and playing the victim. So I think this...
Okay, so a bunch of this stuff can be true at the same time. So Trump can be flexing his free speech, and I think he should, because this is going to cause a real division that I think only the Supreme Court can rectify. Where does Trump's free speech end? Where does the criminal court begin? And who can override whom in the middle of an election where we all want to hear about the weaponization of the Justice Department? So Trump absolutely can do that. And I do think that part of Trump's strategy is that, okay? And I think it's a good strategy, sort of, because he could also get himself in a lot of trouble. But if he's running in an election, he has to talk about it. I mean, he kind of doesn't have a choice but to talk about it. Trump can't just say, yes, I'm going to go along and get along and not cause a ruckus, not draw attention and energy to this case. They would love it if Trump just shut up and they could just prosecute him, convict him with a felony, use the conviction of the felony to send over to the different secretaries of state, say, see, we got a conviction. Now you can remove him off of the different ballots under the execution of the 14th Amendment, removal clause, insurrection clause. All of that can be true. Now, I don't know, the reverse of this can also be true, that the judge is waiting for Trump to step on something so that he can just lash right into him, right? Now, the statement, Trump, was ambiguous. He said he was referring to the person sitting alongside the judge, and Michael Cohen was up on the stand. And so Trump and his defense, and Weissmann brings this up, this is his own point, that Trump and his defense just crushed Michael Cohen. Okay, we were hearing from Alina Abba and her brilliant, incredible cross-examination and backhanding of Michael Cohen in courtroom, got him to admit, as Weissmann said multiple times, dude's a liar, convicted liar, and then got him to change his testimony because he probably broke the law again by admitting he lied to Congress again. And so the point is that the new sanction is the judge responding to a very bad day in court for Tish. Okay, Trump's defense just had a huge victory. So the judge needs to find something to smash that away. What does he find? Oh, an AP article. Some AP reporter writes something, calls Trump to the stand. Trump just had this major victory, but now not so much. Now he's sanctioned with another fine, $10,000, right? And we've talked about this here, but how they parlay off of one another. So now then Chutkan will get another order, and the other order will say, you know, or there'll be another motion saying Trump is saying this thing and the New York court is doing this. That's why you should do this, judge. And then New York will say, well, look what they're doing in DC and you should do this here. And they just keep piggybacking off one another. So this is the game that they are playing. We will continue to cover to see what the ruling ultimately looks like on media access. And then Jack Smith is going to respond to the classified materials being used. Right now, we're going to have to provide guardrails and what can we say? And we're going to have a bunch of new hearings about this. And so it's going to be a lot of fun, my friends. Now, we're going to continue to cover this in as much depth as we possibly can. So be sure you're subscribed. Thank you for sharing it with a friend or family member to invite them on over here to join us. And we'll look forward to seeing you on the next one.